So you got served with papers and you didn't do anything about it and the time to respond has expired. And guess what? You got defaulted. Now, you actually do want to defend the case. I'm attorney Ali Kassoun of the Tropic Legal Law Firm in Deerfield Beach, Florida. We make these videos to bring information not only to our clients, but to other people who want to learn about the law. If you haven't already liked and subscribed to the Tropic Legal YouTube channel, do that now so we can keep bringing you these free videos. In this video, I'm going to be discussing what's known as a motion to set aside a default in the state of Florida. Let's get into the information. If you are a defendant in a lawsuit and have become procedurally defaulted, meaning that you have failed to respond to the lawsuit and the plaintiff moves either the clerk or the court to enter a default against you, you will have very limited ways to contest the case. In fact, a default admits well-pled facts in the complaint. In order to undo the effects of a default, a defendant can file a motion to set aside default. The motion to set aside default is a court document that is filed asking the court to remove the default against the defendant. Pursuant to Florida Rule of Civil Procedure 1.540B, in setting aside a default, the trial court must determine 1. Whether the defendant has demonstrated excusable neglect in failing to respond. 2. Whether the defendant has demonstrated a meritorious defense. And 3. Whether the defendant, subsequent to learning of the default, has demonstrated due diligence in seeking relief. A motion to set aside default must also be verified by the defendant. This means that the document must be signed by the defendant, him or herself, in addition to being signed by the defendant's attorney. Once a motion to set aside default is filed, it should be set for hearing. The state of Florida has a public policy wherein which there is a preference that cases be decided on their merits. Therefore, a litigant who timely moves to set aside a default, asserting a credible explanation of human error, is entitled to be heard on the merits. So now you know a little bit about motions to set aside defaults in the state of Florida. Again, I'm attorney Ali Kassoun of the Tropic Legal Law Firm in Deerfield Beach, Florida. One more time, if you haven't already liked and subscribed to the Tropic Legal YouTube channel, do that now so we can keep bringing you these informative videos and you can keep learning about the law. Thanks for tuning in.